Hello and welcome to Quadcast, Quadrant Chambers weekly discussion forum. We are four barristers from London. That's me, Paul Downs, Poonam Mawani, Joe Sullivan and Claudia Wilmot-Smith. And this is our Christmas edition of Quadcast, as you may have noticed from the regalia we're wearing. The format's simple, I'm sure you know. Drink, talk, chat. We're going to have a drink. I have got an alcoholic drink this week, a Peroni beer. I was going to get champagne and I forgot. But anyway, I've got a beer. And we're going to talk about some legal topics. This week, it's sort of the highlights of the year and looking forward into 2021. And we want you to join in. You must join in. This is really important. And you're going to want to join in this week. So you can either send us an email, that's quadcast@quadrantchambers.com, or you can chat along in the YouTube chat function if you're signed in. And you will all be signed in because you'll all be subscribing, I know, to the Quadrant Chambers YouTube channel, so that won't be a problem in terms of being logged in. So let's do some catch-up news. Let's go to Poonam first. How's your week been?
Poonam's bought her first ever Christmas jumper. I think that's big news for Poonam's week.
For Quadcast.
You want me to show? All right, here you go. There you are.
Whoa!
Oh, God, look at it. Yes, that is my first ever Christmas jumper. I have resisted all these years. I think it's a really weird thing that you people do in Britain. But I have fallen into line. It actually arrived, what was it, 20 minutes ago. I've changed while we were waiting to come on air. That's my news. My other news is I'm taking singing lessons between now and the 20th because I normally have a very large carols party here where we sing carols. But we're going to have to do it remotely. And because of the time lag, we can't all sing together because it will just sound disastrous. So every family is going to do a verse or a carol each. It's about 21 families we do this with. So I have to sing a solo because it's my party. So I'm having singing lessons because I can't sing for toffee. That's my news. What's yours, Joe?
Can we have a little mini rendition now, perhaps?
Do you know what? I'm just held back making a really rude sign because it's...
Poonam, I think there is an exception for carol services. So if you're having a carol service, I think you can have it outside with other people singing, but I think they've got to wear masks. Check it, but I think that's right.
Are you serious? Like 90-something people?
I think so. There was something on the BBC website a few...
oh my God, I love you. Right, I'm going to check that.
Definitely check that, Poonam.
Can I just say, advice offered without any legal responsibility whatsoever.
Emily, look it up. Make me really excited. Right, Joe, what's your news, honey? Thank you, Paul.
So I've been quite busy. I've been doing this trial with Paul, so I haven't been home as much. But I've found this app for my phone which can transform my voice to make it sound like an elf. So I've been calling my daughter and basically sort of tricking her. Not defrauding her, but tricking her into thinking that she's being called by an elf called Elfish. And I've just been having a lot of fun.
That's very sweet, but you are going to mess that girl up for life.
Yeah, well, possibly. But yeah, we're developing a close relationship. How about you, Claudia?
You want to be careful nobody overhears this conversation because people get locked up for this sort of stuff.
How about you, Claudia?
I haven't had any news since lockdown. So my news hitherto has been about elephants suing zoos and enforcing their legal rights or not. And so I thought I'd keep up that tradition. No elephant has sued any zoo as far as I'm aware this week. But the first baby elephant born in Tokyo Zoo for like 188 years or something was born a couple of days ago. And I've got a picture because look, he's so sweet.
Wow.
He made his debut in Tokyo 2 days ago, and everyone can vote for his name on the Tokyo Zoo website. So,
Claudia, I was watching I'm a Celebrity last night, and they did a hide and seek game, and they counted to 100 using one elephant, two elephants, and I thought of you.
See, I'm taking over, man. Me and my elephant news.
Okay, people, look, I've got a quiz. And now there's a bit of a story here because we've been doing these quizzes for the last 2 weeks and we had the same winner last 2 weeks. Emmanuel, if you're watching, you jointly won last week, jointly with Philip Sewell from Shepherd and Wedderburn. So you both should have a bottle of champagne by now. So we're going to do a quiz again, very different this week. Now, I'm afraid...
Paul, I think I should say what the answer was because I've had lots of emails asking me and I've just waited for you to do it.
Yeah.
It was the picture of Jeremy Thorpe and his son.
Oh, yeah, and his son, that one, yeah, sorry. His son was one of the photographers that gate crashed the Douglas's wedding and took the pictures. Yes, Rupert, I think, Thorpe. So well done to Emmanuel, well done to Philip Sewell. Now, the new rule is that if you win our quiz 3 weeks, okay, you will get a special prize. You'll get a magnum of champagne, but that's it. That's you for life, okay? So, Emmanuel, if you're going to have a go at this one, you want to get watching carefully. I haven't told anybody here what we're going to do, so they're all waiting. Now, what I've done is I've sent, or Emily, our producer, has sent to them all a list of every single case that we've talked about this series. And now I'm going to ask each of us to act out the name of one of the cases in a mime, okay, a very short mime. And the first person who guesses all 4 will win. And if it's you, Emmanuel, you're going to win a magnum of champagne, but you'll be excluded then for the quizzes for the rest of your life. So I'll do my one first, okay?
You're completely mad, Paul.
I know, it's fun, isn't it? So just have a look at your list. They're going to get a few seconds now while I do mine. All right, are you ready? Okay.
First word.
No, you don't join in. This is for the viewers. Focus on your... Right, here we go. Just watch, okay? Not sure how to do the next word, so I'll describe that. Okay, that's my mime of my they're all I don't know what it is. Okay. So I'm gonna I'll just say what that one was so that they all know. And who's ready to go next then?
Fine, I'll go next.
The whole thing. Oh wait, no.
That's it. Next.
Who's going next?
Okay. Okay.
I think you're miming below the camera level. I can't see you.
Well,
okay, that's all you're going to get, people. You're going to have to watch it back again if you want to get more. Claudia, are you ready with yours?
Okay. Good luck, guys. That's my
Podcast.
That's the first 2 words. If you can get it from that, then you're great. And if you can't, then I guess.
Okay. Well done.
Do you want to send us the answer on the chat? Okay, so people, first one to get all 4 correct will win a bottle of champagne, and if it's your 3rd win, you'll get a magnum of champagne.
Feel like that champagne is pretty safe.
Yeah, so. Right, okay, so this week's show, we're going to talk about highlights of 2020 and predictions for 21. And the big news, of course, for this year was COVID and the way we all had to change the way we did our jobs in court. And, Poonam, remote hearings.
Yeah, it's extraordinary, isn't it, where we've come from since March in terms of being able to deal with cases. We need to recognise that we're incredibly lucky in our world with the commercial court that people have been able to adapt. The criminal courts, magistrates courts, the difficulties there for people is very significant still. But I'm going to talk about our world. And do you remember, guys, it was in the 16th of March that we were told, it wasn't lockdown, it was like try and work from home if you possibly can. And so everyone was panicking. And on the 19th of March, the first application for an adjournment because of COVID was heard. And it was heard before Nigel Tier, who you guys would have seen a few weeks ago on our thing. And he said, no, you can have a couple of days adjournment to sort out IT, but the courts are here to resolve disputes, and we can't throw our hands up and give up. And my favourite line is he said, we have to be optimistic, not pessimistic. The submission had been that trying to do a remote hearing with witnesses giving evidence remotely would be, and I quote, an unmitigated disaster. And that's why he said, let's not be pessimistic. And afterwards, oh my goodness, first of all, I got loads of emails because Nigel was my ex-people master and a friend going, Nigel Tier has gone mad, what's he doing? And I was like, yeah, whatever. And there's lots of tweets, like Dinah Rose QC said, unmitigated disaster, they were warned. But anyway, you know, it was scary when that happened in March. But I think, you know, on the whole, the courts have been amazing in coping, the lawyers, the witnesses, everyone's adapted. But who has a good story or a bad story to share about remote hearing?
Yeah, before you do, I mean, Hong Kong, I think, shut down all of their courts for 2 months. I mean, it is, I think we take it for granted how quickly the judiciary and the civil justice system here did adapt, and obviously practitioners, solicitors and barristers. Sorry, Claudia, you were going to say something.
No, I think that's right. I think in the commercial court that it's coped really well, right? So big ticket commercial litigation, the court is used to having witnesses in different jurisdictions. It has the potential to make arrangements for evidence by video link. Stuff was done online to a certain degree anyway. And I think that level of technological preparedness has really helped. I don't think it's necessarily been the same in the county courts. And I've had experience in both. The county courts, I think, in some ways, there's been a bigger advantage because the kind of things that so a high-level commercial dispute, you might be able to fly in witnesses from different jurisdictions in any way cost proportional in a county court. So I've had lots of cases where I've been used to evidence coming in as hearsay. Like in my first few years of practice, I go around to county courts. It would be fairly common, for example, if an airline was being sued, they'd never call any of their witnesses because it was a 1-hour trial in England and the witnesses would be in different jurisdictions. Now, having set up for COVID, that has been possible. And I actually had a trial where I had a witness in Ghana who had been supposed to give hearsay evidence, but was able to give his evidence for us, which was great.
Was it great?
Been prepped.
What does that mean? Are your hearings much longer now? Has the 1-hour trial become 2 days?
Well, it didn't take that much longer, I think, but it had been a last-minute COVID adjournment, and then it had been possible to go remote. And so he'd been called in. He granted his offer. But then had been asked. Wasn't sure of the answer. He was in his office, so he went to go and look it up. And he was being honest and completely straightforward and trying to be helpful. He was like, hang on, let me go and check my files. And the judge was just like, no, this is just not how it goes. I think the county courts, on the flip side, have had a harder time because a lot of parties might not be represented or might not be able to deal with remote hearings. So I think on other kinds of practitioners who aren't commercial practitioners. But Joe, have you had to go to court? Have you been?
I've had remote hearings. I mean, the best story though that I saw was not a story from one of my hearings. I read something that a judge said, and then I immediately thought, why didn't I think of doing this? They had a remote hearing where one of the, I think it was a litigant in person, decided to do it from their bed. And whenever someone or the judge said something they didn't like, they just pulled the covers up over their heads. And I mean, that's genius, isn't it? I'm just not hearing. I don't hear this.
Yeah, I think we've all felt like that, haven't we? I mean, the big thing for me, just on a sort of serious note, is the bundling. That's the biggest area I'm finding that you get problems in the document management. So,
Paul, this might be the most serious thing you've ever said on Quadcast.
Well, this is my sort of top pick. The bundles. So, whereas normally in the old world, you'd have a series of paper bundles, and you'd have bundle number and page number, and it was all fairly straightforward. Now, what's happening is because you've got e-bundles, you'll have the bundle number for people who are using physical bundles, which I continue to use. you'll have the bundle number, you have a tab number, you have a page number, but then often the operator is using PDF exported files from the tabs, and the pagination the operator is working on is not the same as the pagination in the bundle. So what you have to do is have a much more complicated referencing system. And then I had one case where the bottom of the bundles were cut off from the export. So the operator was saying it's page 2501, and the operator can't see the page. So that's worth thinking about. I mean, the other thing
more of an incident than an anecdote. That one, I think.
Witnesses and looking at documents on screen, I think, is a real area of concern. You should make sure your witnesses have access to the documents, because what tends to happen is the cross-examiner takes the witness to a page, it comes up on the screen, the witness is obviously completely inexperienced, looks at it, is asked some question about it, whereas in the previous system, the witness will be able to look at the page before, the page after, the emails that came before that email. And so you want to make sure your witnesses are protected. So I even had one situation where the operator was then zooming in on the sentence that the cross-examiner's put, so the poor witness couldn't see the paragraph above or the paragraph below. And of course, everybody likes to play with the gadgets. And the other thing is we had in one case was where the witness at the last minute had a COVID test positive, so couldn't come and physically give evidence. This was a hybrid hearing. So it's all fine, all remotely, but nobody had checked that the witness had a physical copy of their witness statement. So we then had to improvise and flick through the statement on the screen. All these things you don't think about take real much. Oh, and I'll finish with this. One thing, if your witness is being cross-examined, do not trust the screen. Do not trust the screen. You've got to check that what's being put to the witness is fair. So you need the physical or access at least to the bundle so you can check the document before, the document after, because sometimes things are put in an unfair way to the witness. And when you're preparing your re-examination, you've got to be ready and all over it, checking what's happening. And don't trust that screen in front of you. Anyway, look, that's my hobby horse. So that's remote hearings. Poonam, your legal news from this year.
Yeah, so look, we're all going to sort of talk a little bit about what's happened and what's coming up, right? And I said, I've got to do something shipping. And the thing is that this year, there has been the first collision case to be heard in the Supreme Court in over 44 years. So I'm going to try and I can't make this interesting. I'm just going to tell you about it. First of all, it was a collision between a ship called the Eversmart, and we've got a picture of the Eversmart looking very smart. And on this collision, it suffered some damage, about 4 million. But the other ship, the Alexandria, was rather worse off. If we get a picture of her after the collision, she suffered what the Court of Appeal said was $32 million worth of damage. Anyway, the Eversmart was held by the Court of Appeal not to be so smart and to have been 80% to blame. It's a bit esoteric, okay, guys? It's about, we have this thing called the collision regulations, whether the rules in the collision regs that apply to the crossing situation were applicable, or the rules that apply to a narrow channel. I can see Paul is already.
No, I'm just wondering, was it the Eversmart or the Evergreen?
It was the Evergreen.
It was the Evergreen. It was because I was saying she wasn't so smart that I got to it, and thank you. It was the Evergreen. And just so that you learn something about the rules, if you've got a crossing situation, the ship that has the other one on her starboard side has to give way. Anyway, it was heard in the Supreme Court a couple of weeks ago. We're still waiting for judgment. And I'll just tell you this interesting thing about it. The collision regs are not a code of law, okay? Or this is anyway what was argued on appeal. They're not about legal rights and obligations. They're a practical text for seamen and mariners, giving clear guidance as to how to navigate. And what was argued was that what the Court of Appeal and Mr. Justice here at first instance found was contrary to the commentary in the textbooks. And we're all used to arguing that, if the textbooks, if there's a settled view, it's wrong to change the law, right? Because the parties. This was a slightly different argument that was wrong. It was that these books, that had this view were not just in lawyers' offices, they were actually on the bridges of cargo ships, yachts, pleasure boats, giving practical advice to seamen, so that if you change, as was argued, and what the view is in the commentary, you're causing a hell of a dangerous situation out there because these guys are following what's in the book as a code. So anyway, Simon Rainey and Nigel Jacobs of Chambers were for the appellants, and we wait and hear whether they won. But Claudia, we have had Supreme Court decisions in some cases, right?
Yes. So Chubb and Halliburton, which was, we were talking about, it was the one that I think Nigel Tier was the guest speaker. This was where Transocean and Halliburton had both been sued for billions of dollars in the US, had both settled, had both claimed against Chubb on their Bermuda form insurance policies. Mr. Rokerson, we learnt his name, had been appointed by as the chair in the Halliburton reference. When he was subsequently appointed in the Transocean reference, he didn't disclose that to Halliburton. They applied to have him removed. They failed at first instance. They failed in the Court of Appeal. We spoke about the hearing in the Supreme Court, and I'm only going to say this because it's Christmas. Downs called it correctly. He was the only one of us who did. We all thought the appeal would succeed and the arbitrator would have been dismissed for unconscious apparent bias, right? So there was an issue as to whether the arbitrator had been required to disclose his appointment and the consequences of any non-disclosure. And the Court of Appeal said that whether or not there is a duty of disclosure and whether one can comply with that duty of disclosure without breaching confidentiality obligations is fact specific. So there are types of arbitration, such as GAFTA, such as LMAAA, where it's so common for arbitrators to sit in hearings that might involve a common party that the parties wouldn't reasonably expect them to disclose it. But in other circumstances, it may be that that is something they should disclose. There are then issues about whether or not one can make such disclosure without breaching one's duty of confidentiality. In this case, it was something that the arbitrator should have disclosed.
And we were right about that.
And we were right about that. And that was something the Court of Appeal had found too, but the Court of Appeal had said that breach of this duty of disclosure wasn't something that was sufficient to find that the arbitrator was biased or should be removed. And that had made that subject to criticism. And Paul Stanley wrote a really good article on this actually, where it's a toothless duty. And so we were saying, because he should have disclosed and there was a breach, that was something that may justify removal.
The whole thing about, the fear that it was going to go the other way, and that would, well, not the fear, but the belief that it was going to go the other way would then mean that there will be more work for different arbitrators effectively. That's not going to happen, or that is going to happen?
Well, I mean, if they don't disclose, nobody need know, right? That's one of the criticisms about the Court of Appeal. And I guess...
You know what I found really interesting about the judgment was a discussion, because it's always troubled me, of when a party-appointed arbitrator is more partisan to that side. I mean, I remember when I started in practice, I didn't really pay attention to who I'd appointed versus who the other side appointed. And then everyone was like, but of course it matters, Poonam, because there'll be more on your side and you make sure you... And I was like, what do you mean? They're all meant to be independent. What do you mean, my arbitrator? And this is an issue, and different jurisdictions have a different view. And the Supreme Court said, you might think the chairman's even more important. And there's this wonderful phrase that I look for an arbitrator, someone had written an article that has the maximum partiality to me with the minimum appearance of bias. Anyway, it's quite interesting, I think, on a different point, reading the Supreme Court on that. It certainly got me going reading it.
I think that they're going to disclose, though, aren't they? I mean, even though the result wasn't successful in that sense, I think that the practice will take.
So there's a requirement to disclose, but the consequences of non-disclosure depend on the timing. It has to be assessed at the time of the hearing to remove, and that was one of the big things, because it's all
you're never going to know.
To remove,
you're never going to know. You're not going to rely.
Taking a big risk, wouldn't you?
You're just going to disclose, aren't you? You're going to defensive disclosure. That's what you'll do.
Well, I think
what said you need to do it. High-level disclosure is what they called it, of the fact that you're in overlapping arbitrations and the name of the common party is what we need, right?
Okay, people. Now, look, looking forward to next year, what are the big cases coming up? I mean, I'm very interested in this Pakistan Airlines case, the economic duress case. You remember that this is the case about the travel agency, Times Travel, whose entire business was dependent on Pakistan Airlines. And what had happened was that they were owed commission, and Pakistan Airlines persuaded them to sign an agreement whereby they would write off part of the commission they were owed. But it was against the threat that they were going to reduce their ticket allocation. And the problem for Times Travel was a small agency. If that happened, they just weren't going to have a business left. So there's duress, but the question is it tortious? Is it equitable, allowing them to set the agreement aside? The judge at first instance said yes, because it was, quote, illegitimate. That was the test he applied. This is lawful act duress, so it's no illegality threat. And they weren't saying we're going to come around and beat you up. They were saying we won't renew your contract. You'll be out of business. You won't renew your contract. So then in the Court of Appeal, Mr. Justice David Richards said, disagreed that illegitimate was the test, said it was too imprecise, but I think is saying it has to be in bad faith. But the decision's not really helpful, because what he says is the judge found that Pakistan Airlines had acted in good faith, therefore the appeal is allowed. But it opens up this whole thing about, well, what is bad faith? What's good enough? Anyway, Supreme Court, 2 days in the Supreme Court. So it's not a big point, is it? But 2 days allocated to that, and we'll wait and see. But interesting case, I think. What about you, Poonam? What are you waiting for?
Well, if I say this, I mean, if I say the COVID FCA test case, you're going to go boring because that's your view.
Oh, please.
But I'll just bring people up to speed, which is that it was heard.
Can I just go and make a cup of tea while you do this? And
no, I won't be that long. Okay, talk about swiftness of justice, though. Of course, this all came out of COVID. It was heard by the split sort of divisional court type thing, first instance and Court of Appeal judge in July this year, judgment September this year, heard by the Supreme Court 16th to the 19th November, and they've indicated with no promises that we're going to get judgment before the end of the year. Lord Reed, Lord Hodge, Lord Briggs, Lord Leggett and Lord Hamlin. And the reason the last one is interesting is because you may remember that in the first instance divisional court thing, there was this discussion about counterfactuals, causation, but for plus counterfactuals. And in the course of that, they said that they weren't sure that the decision in the Ocean, is it the Ocean?
Orient
Express was correct. They thought they described it as fallacious and said that they would have said it was wrong if they had to. And that case was about Hurricanes Rita and Katrina in New Orleans. But that was a decision of a then Mr. Justice Hamlin. And now here he is in the Supreme Court. And I meant to look up whether this had happened before. I mean, it must have done. So if any of our viewers can actually give us the name of a case and the name of the judge, just for our own interest, as to when, a judge has sat in judgment on his own, particularly in the Supreme Court, I'd love that. And by the way, can I just say I was right? The ship was called Eversmart. And it's the carriers that were called Evergreen.
But the picture had Evergreen on the side.
That's because that's the name of the carrying company. Anyway, by the way, thank you everyone for keeping us straight, because even I got confused.
Can I just say, there is a case, and it's a leading case at the end of the 19th century, where the judge at first instance sat both at first instance and in the Court of Appeal. I can't quite remember it, but it's a surprising case. But there you are. It's a very well-known banking case. Can't remember it.
Yeah. Okay, we'll try and find it. So what are you looking forward to, Joe?
Well, if you cast your minds back to the very, very first Quadcast that we did, I think we did it about Marex and Seberyeka, which was the reflective loss, or they were not meant to call it that anymore. The case about the rule in Prudential, which prohibits shareholders and previously prohibited other people from bringing claims for losses that were just reflective of losses suffered by a company. Well, there's a case that I did this year. I think it was the first case on reflective loss after Marex.
I was going to say it's been a surprisingly long time since we were talking about our very own important cases.
So this is your
I know, no one had done it yet.
Own really important case.
I felt like it was
does sound like a really good case.
so boring. Go on then, Joe. Tell us about your
Broadcasting Investment Group in Smith, and it'll be the Court of Appeal next year. So the judge at first instance decided that the rule applies where the company's cause of action is under the Third Party Rights, the Contract Rights Act, and he held that it applies even where the remedy sought is an order for specific performance requiring transfer of an asset to the company. So that was Poonam's case where she persuaded Mr. Justice Tier that it didn't apply. My judge said that it did. But he held that it doesn't apply to the shareholder of a shareholder. So if you have a corporate shareholder and the loss is a loss in the value of their shareholding, the shareholder of that shareholder, my judge said, is not precluded by the rule in Prudential from bringing the claim. So there's a few different issues. Which of those issues will go to the Court of Appeal is yet to be decided.
Did you see that after the Supreme Court judgment in Marex came out?
Sorry?
Did he say that before or after the Marex Supreme Court judgment?
After. So it was a case where it was my summary judgment, and it was heard in October 2019, and then just waited for the Supreme Court, and then we had another hearing after.
So what do you mean you don't know which points are going up? Surely if permission to appeal has been granted, it's on certain points.
So he granted permission to appeal on certain points, and then the Court of Appeal has been asked by both sides for permission on additional points.
Oh, they'll give it on that. If it's going anyway, they'll let it be fully argued, I suspect.
Anyway, how about you, Claudia?
I'm looking forward to the Supreme Court decision in Grant Thornton and MBS, Manchester Building Society. In my notes, I always think, wait, is that Mohammed Bin Salman? It's a case about scope of duty. So this is Samco, the famous Lord Hoffman's famous mountaineer in his knee. So Lord Hoffman told this parable about a man who goes to see his doctor because he wants to go off climbing in the mountains at that weekend, but his knee has been giving him a spot of bother. So he goes to the doctor and says, look here, dog, am I going to be okay to go on this trip? The doctor glances at his knee and negligently tells him he'll be fine. His knee wasn't fit for the mountaineering trip, but he got squashed by an avalanche or some foreseeable result of mountaineering, but nothing to do with his knee. Can he sue the doctor for the losses caused by the avalanche injury in circumstances where, but for the doctor's negligence, he wouldn't have gone on the trip, he wouldn't have been squished? And Hughes Hall said, look,
Okay. The answer to that's obvious. Obviously, the doctor's not liable.
Right. But
obviously subtle than that.
But it's expressing why that.
And so it's been analysed as saying his scope of duty is for knee-related things rather than avalanche-related things, which in practice, it comes up a lot in a lot of financial services cases where people have given investment advice, and we often have rows about whether it was just information or advice. But if I advise you about a particular product, you invest in that product, you suffer a loss, there are often cases about whether or not that particular loss or the way in which you've suffered loss was A, caused by me, but B, whether it was too remote, whether it was in scope of duty. I see scope of duty under this umbrella of remoteness. In Grant Thornton, in this case, it was Tier at first instance again, and he said the loss is not too remote, but it's not within the scope of duty. The Court of Appeal upheld the appeal for a different reasoning. This was an appeal in which accountants had given advice about the accounting treatment that would be applied to a particular product. And relying on that advice, this building society had invested in these swaps. And it turned out the advice was negligent, but from negligent advice, they wouldn't have invested. Actually, I don't think they did. Side point. But it's going to the Court of Appeal. And I mean, the facts, I guess, we may do a podcast on it, because I think it will be dead good. So I'll be lobbying for this. But it's a really good tribunal, right? So we'll have Lord Reed, Lord Hodge, Lady Black, Lord Kitchen, Lord Sales, Lord Leggett, and Lord Burrows revisiting what anyone who does services must come across all the time, this scope of duty point. And so we should get a really good judgment out of them. And I'm saying that partly because I'm hoping that Lord Burrows will agree with my personal view.
Okay.
Were you counting 7? You said 7 law lords, is that right?
Yeah, that was 7.
Yeah.
So look, we're I think we may have had some connection problems, but so apologies if you're watching and things are broken up a bit, but I think it's sorted now. Predictions for 21, because at the quiz that we did earlier, don't assume that we did all 4 different cases, because we didn't. It was all unrehearsed. Okay, so some duplication. I'm not saying there was, I'm just saying there might have been.
But it may be that one member of us 4 didn't realise what one of them was, and
it may be that one member wasn't reading their chat. Well, I'm giving too much away here.
It's possible.
Anyway, stop.
Right. I want to know what your predictions are for 2021. That's what I want to know, Joe.
Well, I think there might be a bit of a fallout from us leaving the European Union. And
What might be legal implications, Dan?
there may be some legal implications from that. Well, I mean, quite what they'll be, we'll find out, I guess, when we know the terms on which we will leave in a few days, maybe. But yeah, there's going to be all sorts of stuff, isn't there?
Your fishing empire, I think, is going to be under threat, isn't it, Joe? Is that the problem up in Hull? Your
Yeah.
fleet.
My fishing empire. Yeah,
I think the Hong Court's expecting people to maybe bring jurisdiction arguments to kind of test the Brussels regulation.
Whether do we go into the Lugano Convention? If we do, then obviously there are differences between that and the regulation, but all sorts of stuff. So that, I think, is something that will be interesting.
Well, we'll have to do, when we come back, as I suspect we will be, I know we will be in January, we'll have to do something on that. I've got a suggestion. I'm not sure if I can attribute this, but suggestion that Lord Mance may have sat in the Supreme Court as well as the Court of Appeal in Versluit dredging. Anyway.
Yeah, Emily's just looking it up for us.
We'll check that. But if that is true, that's a very good
That's
spot.
right, very good.
Okay, Poonam, what's happening? What's going to happen in the shipping world?
Well, God willing, let's hope, life at some point next year will come back to normal. But I think there will be a everlasting positive effect from what we've been through. We've talked about how fortunate we've been to get trials. And I think in my world, I do a lot of arbitrations. And I think for arbitrations, remote trials allowing and not making everyone travel and witnesses not coming is going to be, at least as often as not. It's not going to be something you have to lobby for. So I think I'm going to see a real change in the way arbitrations are handled.
Give a speech to all the judges at Mansion House saying gone are the days where people will be expected to travel for hours. And then think about in terms of climate change and being green, if you're not making all these people fly in, and the amount of time saving. And speaking, Michelle Calapetis of Chambers does a lot of mediation and this, and he has said to me that he thinks this remote way of doing mediations is fantastic. It concentrates the mind, it gets people there, you don't have this stalling for hours. He thinks it's actually really beneficial. I'm misquoting him, but I think he thinks, it is the better first option for mediation. So if that's right.
I'm not sure I agree with that.
I've heard good things. I've heard people were initially skeptical, like the big cheeses in the mediation world, like Michelle. It's one of those things that people thought wouldn't work until they tried it and have actually had.
Maybe Paul, if we do a podcast about something to do with
there's a lot I could say
and have the two of you have a fight about it.
I did a mediation last month, which we did physically, and there's no way that case would have settled if we'd done it remotely. No way. Anyway, looking forward, banking, I think that this Quince care duty, I think, is quite an interesting one. This is the one duty not to honour its mandate because it suspects there's dishonesty or suspects that there's something going wrong in the background. And for years and years and years, you haven't had any cases on this. And then we had Singularis, and there was that Nigerian case. And I'm told
when he was but a deputy High Court judge, and he'd been gone up by the time it hit the Court of Appeal.
Yeah, it was, yeah. And there's two recently, Hamblin and Stamford, summary judgment. So I think possibly people are going to start to look at this as a way of getting hold of banks. And I did say, didn't I, with all the anti-money laundering legislation and the increased vigilance that banks have to undertake, and find ways of arguing, they should have known, which maybe there wouldn't have been before. And Claudia, what are you looking forward to then?
Well, I think that the FCA test case was such a success that in 2021 we might say another test case. So, for example, when we exit LIBOR.
Calm down, Paul.
LIBOR?
There could be a test case about that. I think it's been suggested.
LIBOR or Brexit?
LIBOR.
Maybe. Oh, no, LIBOR. Yeah. The new, yeah.
So I think my prediction is another test case coming around, perhaps towards the end of 2021.
Don't get me started. Don't even.
That's my early Christmas present to you, my prediction, Paul.
Okay, I'll take the comment about Lord Mounts is correct, but we'll follow it up more carefully afterwards. We can have emails from people. I do want to know. I'm quite interested when this has ever happened. Paul, what are you looking forward to?
Well,
and another series podcast.
Well, all I was going to say is that if anybody's watching and thinking, what's the area I should get into, insolvency is going to be the big area in 2021. There's going to be an avalanche of cases. So if people are looking to diversify, that's the area to move into, in my opinion.
But
so we're nearly out of time, aren't we? So thank you everybody for watching.
What about this picture? Can Ben get this picture up that we've had from Ben Zimra?
Let's end on a more cheerful note than insolvency.
That's a tree of wine bottles that has been procured through the confinement, I think. Wow.
And I think there are other important things we need to see a picture of, Paul, like our producer.
Yeah, I think, can we get Emily on the screen? Hi, Emily.
Hi, Emily.
Thank you very much, Emily. And we were going to try and get our live streaming sort of expert on, Ben Jacobs, Fisheye Productions, but he says he can't do it.
How is it that Ben, who can do everything, can't get a picture of himself? Anyway, Emily,
I won't say the word that Poonam described him as for not putting his own picture up. I just think, thank you, Emily, for your help in the series. Thank you, Ben, for your help in the series. I'm back with the next season of Quadcast on the 28th of January. We've managed to secure Poonam services. I had a real fight with a nightmare, but I've managed to get her signed up again. The trouble is she's got so many competing offers. She was going to go into I'm a Celebrity this year, but we managed to persuade her not to do that and get her on this. But anyway, so 28th of January 2021, Quadcast will be back. If you do not subscribe, I know this doesn't apply to anybody. If you do not subscribe, you must subscribe. Wealth, happiness, health, all follows from a subscription to the Quadrant Chambers YouTube channel. There isn't an issue or problem in your life that will not be solved if you subscribe to Quadrant Chambers YouTube channel. So you need to do that now. If you need to sign up for some, it'll all be fine. Take my word for it. I'm a lawyer. So subscribe to Quadrant Chambers YouTube channel. And I think that to wish everybody happy Christmas. Have a wonderful Christmas, everybody. And we'll see you in the new year. Good night.
Stay well. Take care.